Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. We're coming to you from our awesome Central Washington location here in Cleveland, Washington. A lot less smokier than the last time we were here. Listen, want to talk to you about a really tough issue, domestic violence, and how it brings out kind of the worst in all of us. Don't believe me? Well, we got this really gut-wrenching case coming before the United States Supreme Court next year. We've already talked about it a few times, United States v. Rahimi, which is going to challenge 18 U.S.C. section 922 G8, which is the law that prohibits possession of firearms by somebody who's been accused of domestic violence. And of course, many states have exact similar laws. Well, we have a group now that has thrown their hat in the ring as an amicus, a friend of the court. Hey, let me join in also. And it's not the ones that you normally think of, at least as it comes to fighting against your civil liberties. Sounds kind of weird, doesn't it? So today, let's go through the pleading. Let's see where they're all coming from. And let's talk about, why is the ACLU arguing against your gun rights? Okay, so like I mentioned, the case we're talking about today is United States v. Rahimi. Now, the pleadings are beginning to come in, and what you get at this point is a lot of other parties asking to join as amicus. What is amicus? But what it really means is hey, I want to be a friend of the court. I would like to file a memorandum either in support of the plaintiffs, or in this case, the petitioner or the respondents, one side or the other, because we have another way of looking at it. And I will say here that the pleadings by the ACLU are pretty good. And I will also say that it's not really an I told you so moment, but we've already done a couple of videos, this one here and this one here, where I said, hey, listen, unlike what we were dealing with in Bruin and some of the other challenges, assault weapon bans, magazine bans, and things like that, where we clearly have absolutely zero historical precedent, okay? There's no even remotely close historical analog. When it comes to disarming individuals that society deems as dangerous, oh no, there is a very rich history of it. Now, what I have also said, and we talked about it really on this video right here, is that in many instances, the United States government is going to have to deal with the fact that, yeah, that rich history is all rooted in racism. But as I have stated before, when we have a historical precedent that says, yes, we as a society can disarm individuals who we deem to be dangerous, then there is enough groundwork, at least for the United States government, to reverse or to argue for reversal of the Fifth Circuit's opinion. And candidly, right now, I think there's a high likelihood that the United States Supreme Court could reverse Rahimi. Now, here's the thing, though. When you take a look at what the ACLU claims that they stand for, right in their pleadings, we learn this. The American Civil Liberties Union is a nationwide, nonprofit, nonpartisan organization with nearly 2 million members and supporters dedicated to the principles of liberty and equality embodied in the Constitution and our nation's civil rights laws. Since its founding in 1920, the ACLU has frequently appeared before this court as directed counsel and as amicus curiae, including in cases involving gender-based violence, the Second Amendment, and criminal law. The ACLU is committed to fighting mass incarceration and overbroad gun possession laws that fuel that phenomenon. It is committed to equal protection of the law and opposes the use of gun possession laws to unfairly target people of color. And the ACLU is committed to due process and fundamental fairness for all, and therefore condemns procedures to restrict constitutional liberties arbitrarily without due process or that impose unnecessarily excessive restrictions. But then, here is the ACLU's argument, okay? And though many of you are going to disagree with it, and that's fine. We are always subject to disagreement on this channel here, okay? We're not going to tell you all how to think. I'm just going to give you the stuff to think about. But this is a legally sound argument, as the ACLU puts it, because they are saying that the United States Supreme Court should reverse the Circuit Court's opinion in Rahimi. And they state it as follows. The United States seeks reversal by asserting sweeping government power to restrict the Second Amendment rights of anyone who is not a law-abiding responsible citizen. But the court can and should reverse on a much narrower ground without granting the government the broad authority it claims, namely that there is ample historical support for restricting gun rights of persons individually determined to pose a specific threat to others. The limitation on gun possession at issue in this case does not sweep categorically, but applies only to individuals who are subject to specific domestic violence protection orders and lasts only so long as those orders are in place. Because there is historical support for limiting gun possession by individuals adjudged to pose a specific threat to the safety of others, the court need not and should not adopt the United States overbroad theory in order to reverse the decision below. Accordingly, the ACLU files in support of reversal, but offers a significantly narrow basis for that result. Now, the ACLU goes through a long analysis, going through Bruin and other cases to determine whether or not this is the type of activity that obviously falls under the Second Amendment, which it clearly does. However, the ACLU then begins to pivot to their position by stating, but this case does not present such a policy or constitutional questions. It asks only whether one particular gun regulation, which prohibits firearms possession by persons subject to certain domestic violence restraining orders, on its face violates the Second Amendment. It does not. The ACLU then makes the following arguments. The Bruin framework authorizes disarming individuals judicially determined to pose a specific threat of domestic violence. And there is actually plenty of language in the Bruin opinion that suggests that. The ACLU also points out the prohibition here falls within a historical tradition of disarming people individually adjudged to pose a specific threat of violence. Now, this is where I mildly disagree with the ACLU, because if we take a look at the long tradition of gun restrictions going all the way back to before the Declaration of Independence, we have pointed out time and time again that these are all based in race. So this is a categorical restriction. So for them to suggest this is based on individual circumstances, that is wrong. However, society deemed those individuals back in that day, as backwards as it may be, categorically to be dangerous. The difference here is that Rahimi is being deemed to be dangerous individually, and that's based on objective allegations against him. Now, the ACLU then goes on to justify civil protection orders with things such as firearm restrictions tied to domestic violence restraining orders directly respond to grave problems. And what I would suggest to the ACLU there is that when we start talking about the balancing test and responding to certain grave societal problems, we're getting dangerously close. In fact, we are getting completely outside the confines of the Bruin holding. And they, in many ways, late in their pleadings, I think, convolute the issue a little bit. I think the ACLU, if you take a look at the first half of this brief, has actually made a pretty good argument. Now, the problem, of course, is that I'm speaking objectively as we apply the law. To all of you subjectively, you have an organization called the American Civil Liberties Union, which is okay with your Second Amendment rights being taken from you without due process of the law. Because let's remember how these orders are effectuated. A person is arrested. There are allegations made. There is a finding of probable cause, which means it is slightly more likely than not that a crime was committed. At that point, the court has authority to order forfeiture of the firearms. Rarely, if ever, do defendants have an opportunity to comment on probable cause. And even if they do, it's oftentimes a really dumb move from a strategical standpoint. So these gun rights are being taken from these individuals without actual procedural due process, which is both notice and a meaningful opportunity to be heard. If the ACLU focused more on the procedural problems, okay, the Fifth and Sixth Amendment problems that come with the implementation of these civil orders, it's entirely possible that if they truly stuck to their mission, their brief would have been a lot different. However, they have chosen to argue here that this is permissible under the Second Amendment because there is a historical tradition of disarming those that we deem to be dangerous. And the problem for everybody in the 2A community, and those especially who are rooting for Mr. Rahimi, is they actually may be right on that. We're going to go ahead and link up the brief down below so you can geek out on yourself. I'm sure many of you will have rather colorful comments, and I look forward to all of them. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is right down there on the description box. Now, in the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.